Okay, FM 101.7.
Na enkomo yi mu na mpese me call lawyer Godwin Edu Tamakloe. Na ye kwaji ne thoughts on that. Where officer of the court. Edu Esquire, memoache.
No problem. With you.
Na bako die.
We should have Nyankopon.
Die si wo enura eye Gregory Afoko try ayi. Wo be friend say.
Media maka. Me say interesting justice.
Interesting justice.
Interesting justice.
Why?
Kwame, you see, Ghana, you were back on Sempao. Would they win it? Wouldn't we say, now your interior minister be your friend of Krobo, do say?
Hey, Krobo, yes.
Na Nkrumah Breso no. Na Nkrofo bi wo mamu ha. Sometimes omo Nkrumah find say Onyomo enyadwin ana omo criticism of him no onyomo enyadwin ana say you are engaged in activities the government considers or the Ministry of Interior considers to be unbecoming na yes you be deport yomo inti say you the deportation you chomo say you deport yomo omo to challenge the deportation inti no ombeko court omo yesu omo challenge deportation. I'll go say, oh, the next day na Minister of Interior no order say inform unko. And to go say immediately they are taken out of the country. And Brakwa asem no court to. Inti no ombe style
Mame ma ba kokura ba ko bi kura ye na esese prosecutor bi efiri nyire hia buruchire eba na woni Kwame Nkrumah de besie ni wo mram eno no na yesoma akroba adu sei enti akoa no bedu ho na bedu airport no no as Minister of Interior no in and out. Yes, I want to try prem ko
Inti welcome inti na de obeya na say before a judge no be giving a decision na we go say na wa deport so the contempt application at the beba against no. We will say quickly, 60 for us, no more doors or parliament. We will say quickly, no mark of parliament, no mark of pass the FN or ad hominem legislation to make nonsense of the court's decision or be making. We will say decision comes effectively authorizing or giving approval. Emma dear Krobo edu say ayade why no. All these things mean to know. Emra ni ye 1992 constitution no. Ye so ye will be a friend of separation of powers. Ye will independent judiciary, executive, and the legislature. In a omuni no ya momu respective functions. Now American jurisprudence no cry the say even though they are separate no. There's a certain level of interdependence, such as yes, Attorney General or file criminal prosecution or charges flowing from the powers given to the Attorney General under Article 88. Now, or the seminal accordane court independent of the executive. Into court so ever share the facts. No, I share Article 19, fair trial rules. The first rule will say a person is presumed innocent until his guilt is proven or say what pleaded guilty. Now, you say immediately an accused person says, "Say, I am not guilty." A rebuttable presumption in raising against their oath. So now the burden shifts onto the prosecution, say, who will need the evidence to prove the guilt of the person. Now, Ushia, in the case of Gregory Afoko, no, Kwame, somewhere 2015 in a buying attorney general then added the criminal charges of murder. Now the law on murder is first. You do call the FN committal proceedings at the district court. District court judge no be evaluate evidence the FN of bill of indictment. The summary of the evidence against you or share no okay. I think there is enough evidence for this case of murder to proceed. So you will now commit you for trial at the High Court, just by way of the procedure. Now, Brother Kwame, we do High Court now. I feel now the prosecution are calling on witnesses to establish the essential element of that murder charge. Now, when you say murder, you can't murder near patch say, no nipana owu ye no owu ye through harm. Na sa harm no wo na wo cause sa harm no. Na one who say unfortunately murder no won't mean cause obi pene so say min kumu no into me kumu no won't mean cause that. So that's it. Into they have very very limited defense. And one say either you are not the one who did it. Now, Kasimin, I was provoked. Unim say pray or beat me, but I was provoked. Provocation, crano. It does not give you complete defense. It's not complete. It is still you can be charged for manslaughter because your intention may be negative, but prison there, obeko. Even with provocation, it's a be or honor. I was provoked. That be even provocation will not be sufficient for you. Now, Kwame. The issue who Afoko trial winners are quite very interesting. And it's not make us say interesting justice. When we say in this trial, no, the only evidence linking Afoko, so-called, to this case, no, dear friend, Chairman Adams, may his soul rest in peace. The baby and the bush and for it's not good to lose the family. It is, and so I empathize with the family. I sincerely do. Now, Brother Kwame, the say, in the particular case of Gregory, the only evidence the Republic uses to link him, and then they say, the wife, now widow, of Chairman Adams, say, Nikunu etrende say, a year Afoko in the night in a true acid no a good so. Now in the law of evidence no when we will be a friend hearsay so Mr.
Yes.
Now hearsay evidence general rule is it's inadmissible. But there are certain circumstances where hearsay evidence is admissible. You will be a friend of the law of register. And they say Obiaka Sem Okayana Ouye. No, so Edugina ASID. Okano, Potokasam contemporaneous with the event in such a way, say, at any time, no, to me, I rely on the Wakano. It is a memory backwards number because you, before Eduji, no, son, Wakan, you. Even though a hearsay, no, the court is minded to admit it once it fulfills the law on register. And the law on register, because it is an exception to the hearsay rule, no, and very technical and limited. So obviously, no, right from the trial, from the beginning of the trial of Afoko, the prosecution had a very difficult burden. And so what you do is that you look for the corroborative or the circumstantial evidence. You need direct evidence.
So was it right from the word go? No, now prosecution no burden no. Aha. I didn't money yet dinner, sir.
Who need direct evidence,
okay.
As at the time, you share acid in the good no so no. Miriam can say no jina ho in Afoko if you good no so. Then that one will be direct evidence, eyewitness, say ono na ye. So just we no or say, even though na me ni ho emre kwa Afoko allegedly ehwe acid no go ni so no. Me kunu emre kwa before be wu no oka kire me. So it's like reported speech and yet direct evidence say me hu say oh yeah. Bra kwa me otimase. Aha. So now it is now going to be like a reported speech, hearsay. But the law of evidence allows it to be admitted as register if it is contemporaneous or if there is no opportunity for the declarant, say, or fabricate the story, or say, or you're motivated. Now, in the case of Chairman Adams, unfortunately, no, okay, the event now echoes so now. Tama Chairman Afoko and the Kwabna Japan echo Borga Hotel Hono. Chairman Adams lead one group, Moko Atakeno. The new brain assassin no a year. So already no, you can see that there have been some undercurrents. So therefore, there is a high possibility, say, even before the wife came to court, no, she knew that the husband had an issue with Afoko. So it makes it very difficult, even with the law on register, to be entirely relied on, based on the exception on hearsay. So already, now the prosecution had a tall order. It's okay in the whole trial, no, almost call it 14 witnesses. Like I told you, because they had, you see, the law of evidence said that you do not count evidence.
You do not count evidence.
You don't count evidence. You weigh the evidence. And then they said, would the incrophobe break or quarter? And then they say, one some year there. You can actually go to court with one witness. And that witness, once it's established or a witness of credit, no, the testimony or evidence before the court will be given a greater weight. Over 14 witnesses are audio maba. If the prosecution is able to, the defense is able to establish serious inconsistencies in their testimony. Because you see, the more I wouldn't go for a court as your witness, the likelihood say Obiaba can't different things. Especially so when they all did not witness the event. Into Weber can't say. Into Oshia, in one breath, Obi said, acid now, acid, the same container near whom were Gregory Ho. Then Obi said, oh, Dabio, you Krobi or Gregory Ho. Chrono, yes, suspect say, acid maybe they feel good. So then a doctor comes and said, no, I examined the wound and noticed that the wound could not be as a result of acid or eguno. So already, no, you have undermined your case largely. Two, the issue who said murder trial, no, it's also trial by jury. Into judge not to ho, then they are jury. Almost so ever assess the facts at the Abua judge. No. Now, murder trial, so no, the issue who say the verdict must be unanimous. It should not hang. If at the end of the day,
jury no, Sebia almost 7. You bet me 2 of them
all the
dissenting
7,
to it.
all the 7 should agree. Say 1 hour, yeah.
Say 2 dissenting to the.
It's a hang. It's a hang jury.
Okay.
It's a hang jury case, no. Now and one say there has to be a retrial. What I say, right from the word go, no. Now the prosecution had this very, very, very tall order to surmount because they had no direct evidence they had to rely essentially on the law on register and circumstantial evidence.
Now, the maybe son say. Naturally, say, a jury near 7, and 2 of them are of decent views as to whether
it's a hang.
It's a hang
way. It's not unanimous.
As I said, jury come
and
out.
yet, and no say with the abba. evidence no is conclusive. So now, yeah. What I say? Aha. So the verdict must be unanimous as to say, oh now, yeah. Now, the Akoba in all of this, Gregory Wanya Bello for almost 4-5 years, 2015 to 2019. Into prosecution, now having called 14 witnesses, say we have closed our case. Afoko opinion different. Onankasa testify in our offer ne brother. Into no crowd or can't class you. Sana Juna Sam no buy no. Father, quite old. Into a Busiana ma no in a tnaho. Sebi where the man no that's minaso. Men I am Mrs. Ne diapers and then home. So I could not be where they claim I was. And I need no be corroborate here. In fact, or a way, anyway. So as I said, into the judge then adjourned the matter. Say, on this day, I am going to now give further directions and then a day for judgment. So within that period, a judge now adjourned the matter, Now Republic, FLA, why wouldn't be a friend in Nola Prosecutor? Within the powers Attorney General under Article 88, any the Criminal Offences Act, any the Procedure Act, or such to file Nola Prosecutor at any time before judgment. So the Attorney General rightly so exercising the powers in all filing. So you're discharging. So immediately he was rearrested with the view, say, the so-called accomplice along the Yachino. So now they want to start the trial all over again. Quite interesting proposition. Because the entire evidence are Republic no war no. Almost be too as though he was tried with the other accomplice. But like I indicated, Attorney General was at 2 million. So as I say, that power within the statute and the Constitution. So in between this period, you are arresting while they are interrogating the other person. The lawyers approach the High Court, differently constituted, and are making this bail application. It is His Lordship Justice Michael Boedi. Attorney General filed affidavit in opposition or evaluated the entire evidence, coming to the conclusion, say, look, one, say, at any time, as Attorney General, who will to me say you can file nolle prosequi. 4 years down the line, you file nolle prosequi. Is it the case that evidence now, what they call court, in the first trial, you didn't believe, said that evidence could lead to the conviction, so that you can now say, with a new evidence. So it means the quality of evidence now, what they call court, in the first time trial, now we need evidence, Lindy, but just because you wanted to do something. Better still, the right of an accused person, the presumption of innocence, may use the refusal or grant of bail and punish the accused person because there is a possibility, say, the outcome of the actual case may be that he is innocent. By that time, now I serve you over 7 years in prison. And also I serve you over 8 years. Already, why almost 4 years did that. So under the circumstance, I'll grant him bail. Not you. At the sum of 500,000 Ghana cedis. That is Afoko Jania. That's how much the Republic, the original authority, that's how much. So, basic, judge now set a very stringent conditions. Now, based on these conditions, the family members are assigned surety at the landed property. Landed property are ordered by, at least for the first time, interestingly, Republic at the property, document, at the core, architectural and something, AESL. I don't know, government architects at the core. And a government architects, evaluation to be sure, crash a property, no. Almost share na property, no, is valued more than the 500,000 Ghana cedis, no. So it means everything is in order. And now, they call the registrar of the high courts. Registrar no so share BBR. No, so yeah, this one is perfect. And was satisfied. Bill conditions fulfill everything. Why the warrant, see and discharging of BBR. I feel I could do Ghana police wa. We share the Nima radio service every Yonko shipping Kruma. We share the Yonko Nima no I say Kakra. We share the Yonko Nima now or they call Madame Tiwa now or they call IGP name IGP Sha I say order from above. When we say order from above, Black Kwame, na end na according damage. Unim or worry, say to worry no. Aha, into we can we say, men are menko. We now they have left the poor police officer, Chief Nkrumah, in the middle of fire. It's back and forth, back and forth, back and forth. And one is there. Attorney General quickly said, Dabi. Sabelia Justice Gwedi Aye Menfuaso. It's quickly almost file a notice of appeal against the grant of the bill. Now, Bakwame, almost file this notice of appeal, no. In almost mounted the FNO stay of execution application before they say Michael Gwedi J. Now, my Lord Michael Gwedi J, I don't think there is any merit in the application. Into a dismissal application. Whilst the appeal is pending, the notice of appeal, quickly, in our republic, a court of appeal, a repeatee the stay of execution application, pending the outcome of the appeal. In our court of appeal, you should evaluate here and say that we find no merit in this application. No more dismiss the stay of execution application. So now the option left for the state is limited. So now the state decided to use its power of eminent domain to disrespect the court order. Whether there is an order for the court or not, will not release you. The OBABR. The lawyers of Afoko applied to the High Court, differently constituted, citing IGP and Madame Tiwa for contempt of court. Now they don't come to court. The judge makes an order, come to court. The last time Omo called court cried there, Omo by a seal. The two of them are not in the country. So judge now adjourned the matter to a different day to give a ruling. Now only for the matter, not you, because now they have rearrested him, they have filed fresh criminal charges and reconstituted a different high court, now presided over by Her Ladyship Amelie Wood. That is where the prosecution now goes and make an oral application, sir. Yes, we are aware, sir, there's a bill from a different high court, but we want you to rescind the bill. We want you to more or less vary the bill, whatever it is with the bill. And the grounds are Republic, a canvassy, a black woman, and then they say, Afoko, your money bill, on standard trial, obey Jamie. Black woman, Potocas, and you will be a friend of bill when you're fighting on pure affidavit evidence. So, on the face of your affidavit evidence, you might demonstrate, say, Ebia Yama Afoko bill that, and one jump bill. So, on the way, you jump bill. Sort as it, because why you be that? It will end say, now, Obia Waman bill. You have not even allowed the person to enjoy the fruit of that bill. What a different judge will say. The same arguments now all canvass it before the different high court judge now all refuse. You go to a different high court and now says, oh, I acquired the woman the bill crana obejane. And on the basis of this, the judge exercises discretion it were to, Now, Brakwame, okay, the famous case of Riakoto. The famous case of Riakoto, Chiame Bafos Riakoto. So, kind of LLM activities.
Yes. I know the idea. Obia was shallow, Obia.
A ceremony cry law school, ye be a law week crana, ye the reenactment of the Riakoto trial. You see, there was an interesting thing between J.B. Dankwa, who was the lawyer for Bafo, or Chame Bafo Riakoto, and the then Attorney General Geoffrey Bain. That was the Attorney General for Osaje for Dr. Kwame Nkrumah administration. Now, Emra Asamnubai, in fact, as lawyers, we always say that when it comes to habeas corpus application, nobody knows it better than Dr. J.B. Dankwa.
Hey.
Because, yes. We study the law, cross-jurisdictional analysis of, in fact, what kind of area could you say a lot of industry and work went into it. The whole way, and say, we have a certain abacusum. How government in the past have behaved. And these are governments persons associated with the New Patriotic Party describe them as dictators and Crawford demonstrated dictatorial tendencies, impunity. Say court and make you order. I say I won't respect the order. Now, once that thing happens, what it does is it undermines fundamentally the respect for the rule of law. And so for me as a legal practitioner, Ubiamako Sukru Kakrebi, Amakai, Nanado Danko Akufo Addo, the case, as Prez Akufo, cases on Lancaster on habeas corpus, and I am so disappointed, sir. In administration headed by no other person but Nanado Danko Akufo Addo.
But
2019, we are not, hold on, we are not talking about 1951, 1952. This is 2019 Ghana. Rakwame, you see, I am not interested whether, this is being done to Afoko or anything. But as a lawyer, if my client, this thing should happen to him, what will be my reaction? What will be my reaction? Today, it is Afoko. Now, when you say, "Yen will be a Magyasi, Ayatra, Tonomomato," say you there, you shall be an accused person. Assembly a tunipa. Assem tunipa. Assem a tunipa. It is assembly sa bar. Men can say, "And ne a Afoko." Ebi etinamo na abeye adodankwa. Ba no ye na ado. Ba no ye adodankwa. Ebia na akoto tikesie ana educhi. It is a yen law. Yen say etina demuntin no. How would posterity take this matter? This particular one, dear, sebe. Miss Runtino main Casabiu, Rakwame.
Lawyer!
Rakwame.
You better say, now if you say, dear nurse, one year, avenues are available to them, they say.
Now, Rakwame, order no cry, cry, Yembuso. What else can you do? A court gave you, granted you bail. The Republic says, I won't respect it. Yeah, we don't care, whatever the court says. You are ultimately.
Matthias, yeah.
It's O'Connor, another court, grandma, Emma, another bill. And you see now, there's one by High Court, it has been rescinded. Can you go to a different High Court for a different bill? Because you see, Bro Kwame, the fundamental principle under our Constitution is that even the judicial power crown, it emanates from the people of this country. Now, when you say, when it comes to judgment, the only reason why you and I, court, say, at the end, the court, the two of us will respect it. And say, decision, but now one of the parties decided so. Even though the court has spoken, I will not respect it. And this person is led by the number one law enforcement officer, the Attorney General. You are sending a message to the ordinary citizens, as for the Attorney General, as for the executive, the president, and state actors, they are above the law. So the whole business of equality of the law is only applicable to the poor and downtrodden. Once you do that, public confidence in how the state is organized will be undermined. I am surprised that this thing is happening at the time when we have a president like Nana Dankwa Akufo Addo. Obinekai, or if you want to know the true character of a man, give him power.
Now, my question is, say, me no dim komo ini earlier submission who can be of the independence of the executive, the judiciary, the legislature, and the keka home. It's other na won't treat him matter and say ye BB, whatever you call it, travesty of justice, whatever you call it, you know. One can say, and ye attempt woman, as a moving ye, than to lay it at the doorstep of the president.
There was a bail order. The executive, hold on. Prosecution is emanating from the executive.
Oh, okay.
Attorney General, executive arm, Article 88.
Okay.
Clearly specified there. Who appointed the Attorney General?
Is the president.
So what are you talking about?
Afeni Matiasi, I come in Miss Medasi, bye-bye. Bye-bye. Okay, 1.7 in lawyer Edgy Tamakloe. And I know air tree and Conway.
Okay, FM 101.7.